And we're joined now by Mpumelelo Zikalala, legal practitioner at Zikalala Attorneys. A very good evening to you, Mr. Zikalala. Thank you so much for speaking to us. So just look at the foremost implications of the Electoral Amendment Act. As we mentioned, the inclusion and nomination of independent candidates as contestants to the elections in the National Assembly and provincial legislatures for the first time is one of the major issues. The IEC had said that September would have been an ideal time to receive the judgment. Just hearing from you your thoughts on any material difference that this ruling will make on preparations already underway.
Good evening to you and also to your viewers. I think the most important one is sort of the barrier to entry, which has been created by the regulations that we have now. Independent saying that you must have equal share and be eligible to contest in whatever manner in which political parties are able to contest in. When it comes to us as independent, you need a threshold of individuals. However, when it comes to political parties, only 500, if I'm not mistaken, or even not more than 2,000 members that you must say you must have. Now, that makes the balancing forces very, very different, because it's easier for me to create a political party to go and contest elections than to be an independent and go to parliament and be able to contest on that basis. I think that's the first one. And then the second one is the issue of saying, once I've contested and I've won, how are you going to allocate those seats to me? How is the situation going to be? Or are you then creating a system in which political parties are going to engage in essentially in what we call double dipping? They have an access to the national ballot or to the national category, and also to the other 200 seats that are left. They also have a space in which they can play in within that particular sphere. Now, the balancing forces of all the two, where do you get it in, and how do you make sure that every single process that is going to be there is going to be fair? But on the other side of the coin is the process of saying, if you open the gates too much, you are going to have a flood of new independent candidates which are going to come in, a ballot box, paper which is going to be longer than what you can be able to handle, making the printing section of it very difficult, and the administration of these particular elections a bit difficult. Now, in the middle of this, we have the IEC that says we have a strict timetable because elections must be held between May and August, if I'm not mistaken. And within that particular time, we must have made our things and make sure that everything has been done correctly. So if the court issues a judgment tomorrow that says the act is on par, there's nothing wrong with it, then I think the current timetable, which is being discussed by the IEC, will then be able to continue. But if it says go and do a few amendments or read into the section, then the court is going to be forced to get into the shoes of the legislature, something which I don't condone, and to sort of read into the act certain things which can be able to cure whatever deficiencies or where the current act is lacking from, in order to protect the rights of the independent candidates.
Can you just expand a little bit more on why you don't condone it?
Well, there's a reason why you have a legislature section in the judicial. The judicial is simply there to say, let us interpret and check whether the law was complied with. Our courts are not there to be as legislatures and to read in or to write what the law is supposed to be. And which I've found to be a tendency that's just been taking on for quite some time now, where a judgment would be issued and the order would say, we're giving you an X amount. Firstly, we're declaring this particular section unconstitutional. That's fine. They have the right to do that. And then secondly, we are going to give you 24 months in order to remedy the inefficiencies or the constitutionality part of it. If you fail to do so within the 24 months, we read into the act the following words. That is basically writing the law and become the legislature yourself. Now, you can't be a referee and the player at the same time, because the question then is, if I go to court on the next occasion, querying or alleging the unconstitutionality or asking the constitutionality of that particular provision which was written in by the court, then what are the chances that the court is going to say, we were wrong, we did not take into consideration all the things that you ought to have taken? But most importantly, where is the public participation factor coming in, which is core and essential to our legislative drafting, and making sure that we have rules that are sufficing when it comes to the most basic democratic principles. The people shall govern, and whatever the people are saying must be written into our law is something that must go in there, which is why I have a problem with judges writing into the law and into the judgments, detailing how the actual legislation should be. That is not the role of judges. The judges are simply there to interpret the law and not to draft it.
So just going back to the issue of the inclusion of independent candidates and this revised formula, as it were, because of the amendment to the Electoral Act. I want to then zero in on our electoral system. So how would the allocation of seats and the reallocation in the event of vacated seats then work should the judgment be favourable to independent candidates?
Firstly, you need to understand that there are mainly 400 seats, if I'm not mistaken, within our parliament. And depending on the number of people that came out to vote and the number of votes in which you are going to get, then a proportional percentage is then allocated. So if the ANC, for example, have got 60% of the votes that are there, then in parliament they're going to get 60% of those particular seats, and that's how it's going to be allocated. Now, moving on to this new dispensation now, you are now going to have 3 ballots instead of the 2 that you previously had in the previous elections. Now, saying that the first one covers the National Assembly, the 200 seats, which are for political parties. The second one covers the political parties and independents, so that's where they get their share, and which is a bone of contention, if I'm not mistaken, saying that why are you only limiting us to only 200 seats or 200 independent candidates that can be there? Open up the space so that if we want to have 300 independent candidates, so be it, so just as long as we have the systems and the number of people that we require. And also we're able to say these are the number of people that are willing to vote for us. And another one is do not limit or put a threshold which is too high to say we need 15,000 voter people that are in the voters' roll that's saying that we are going to vote the particular independent candidate. So once that process has been done, after the voting has been done and the votes have been tallied, you then see how many seats can then be allocated to a political party, how many seats can then be allocated to an independent, which in this case, it is only 1 seat per independent candidate. So regardless of how many people vote for you, just as long as you've sufficed in that particular threshold, that's where it's going to end. Now, on the principle of fairness, if I receive, for example, 2 million votes from South Africans, I'm only occupying that seat, or that single seat. Meanwhile, the people that are behind me, that I'm the voice of those individuals, the number is increased. So it's only the principle of fairness to say how we're going to accommodate the independent candidates, how we're going to make sure that you are taking the views of the people and the will of the people into account when allocating the seats to political parties and to independents.
And just finally, the provisions in the legislations to objections to independent candidates, how would that work?
That would be similar to what is happening now. So once the process has been done and dusted and all the registrations have been complete, then through the government gazette and through the website, I think the IEC would issue out notices to say, these are the independent candidates that you have within the political parties. Here are the political parties that they are. Here's the list of individuals in which they want to nominate to parliament. If you have any objections, send them to us. Certainly, if they go against the law, for example, they've been convicted of certain criminals, they've been declared as insolvent individuals, or they're not South African citizens. So it's on those bases that after that process has been done, it is then open to us as members of the public to scrutinize that list to see, is the person that is supposed to be there really eligible? Do you have any issues that you might have? Is there any information that maybe they might have missed from the IEC? Then it's up to us to say, these are the candidates that are there. It's fine. And once that let's say public consultative processes has been done and any objection, or the window of opening up any objection has been closed, then the voters' roll will be closed again, and then we can go and vote for those individuals that have been approved.
Thank you so much for your time and sharing your thoughts with us. Mpumelelo Zikalala, legal practitioner at Zikalala Attorneys.